Hello everyone. Today I will discuss in this video is the continuum of ADR, that is the alternative dispute resolution. So before starting the video, let's understand what is the meaning of the continuum. Continuum is a straight line on which we will see where the different methods of dispute resolution like litigation, arbitration, mediation and conciliation fall. Okay, so that will decide the properties of all these methods of adjudication, and that will also give you clear distinction among all these four terms. Okay, so after watching this video you won't have any confusion regarding any of these methods of dispute resolution. So let's first see the first continuum, that is adjudicative and consensual. So see where all these four terms fall. The first one is litigation. See how close litigation is towards adjudicative and how far it is from consensual. What does it mean? That here parties have no scope of having their consensus regarding anything. Once case is filed in the court, it is only the court that decides the issue. Okay. The second term is arbitration. See where arbitration falls, it is less towards adjudicative and more towards consensual. What does it mean? That here parties have little or comparatively more freedom. Okay, now the next term we have, that is mediation. Okay, see mediation very close to consensual, so it is complete consensual, right? And the last term that we have, that is conciliation. If you see, conciliation is a little right in comparison to mediation, where it is consensual, of course, but since conciliator has a little more active role than mediator, so it is a little right in comparison to mediation. Okay, otherwise both are same. Okay, so on this continuum where one side is adjudication and second one is consensual, you can see where all these four terms fall. Okay, so now you won't have any confusion regarding this. You got the difference among all these four terms. Now check out another continuum. What is all about it? It is neutral decides outcome, and the second side parties decide outcome. Okay, so see neutral means what? Judge, okay, or an arbitrator, and the second side, that is in the left side, parties decide outcome. So see the first one, of course, it is litigation where judge decides, court decides, so how close it is you can see. Next one is arbitration. Here again party has very little control over the thing because it is arbitrator who decides, right? The next one is mediation. See how close it is towards the parties decide outcome and how far it is from neutral decides outcome, because here parties themselves decide the outcome completely. Okay, and next one is conciliation. It is a little again towards right in comparison to mediation, because as we have discussed, conciliator has a little more active role, so conciliator influences the decision of parties as he suggests or gives some solution. Though it is different story that whether parties accept that or not, but conciliator suggests. So it is in comparison to mediator, it is a little towards right. Okay. Now check out another continuum. What is all about it? That is, parties have control over process and parties retain control over process. Again, litigation is very close to parties have control over process, and again arbitration is close towards parties retain control over process, but though it is more towards parties have control over process. So next one is mediation. Of course, parties retain control over process. Okay, and again conciliation. So same difference on every continuum you can see here. Okay, so parties retain control over process means everything is in parties' hands. Okay, parties have control over process means what? Parties collects the evidence, as you can see in the litigation. Parties can hire representative to present his matter issue in the court. So such process kind of things parties manage, but here party retains control over process. So you need to understand the difference between these two terms. The last continuum that we have, that is formal and informal. Okay, so see which one is more formal and which one is less formal. Of course, litigation is complete formal, arbitration comparatively less formal, mediation comparatively again very less formal, okay, and conciliation again similar to mediation. So we have seen the differences among all these four terms on the basis of four continuum. Now I believe you must understood the distinctive meaning of all these four terminologies of adjudications. Okay, so from now onwards I believe you won't have any confusion or any doubt regarding any of these terms, right? So now you would have the clear picture of all these four terms. Nonetheless, if you have any confusion or any doubt, you can ask through the comment box given below. See you in next video.